I want to introduce the team, though they probably don't need it. Dr. David Starkey, one of Britain's best-known constitutional historians. He has written numerous best-selling books and presented television series on the subjects including Henry VIII, Elizabeth I, the monarchy, and the Churchills. In April, he has a new book coming out, Magna Carta and Us. Diana Rose, QC, is a barrister specializing in civil liberties and public law. She represented Julian Assange in the Supreme Court and Binyam Mohammed, a British resident detained in Guantanamo Bay. A fierce opponent of secret courts in the UK, she is also currently acting for The Guardian, seeking disclosure of letters written by Prince Charles to government ministers. And then there's Rory Stewart on my left. Rory Stewart, OBE, Conservative MP and best-selling author. His career has included a 6,000-mile trek across Afghanistan, where he founded an NGO, and an official posting in war-torn Iraq. He was presented television documentaries on subjects including Lawrence of Arabia and Afghanistan, and was last year elected chair of the Key Defence Select Committee, in which capacity he published a report today on the failure of the UK to respond to ISIL. In the audience, we have also got distinguished guests. The ones I'm going to name are David Carpenter, Professor of Medieval History at King's College London, who's written a new translation and commentary on Magna Carta. He just says to me the other day he doesn't like compliments, but I think it's a superb book, so I shall just encourage you to buy it afterwards, where he will be signing copies. And my old school friend, Edward Folkes, Lord Folkes, QC, Minister of State for Justice, who has, as a member of the Justice team, is critic of the expansion of rights under the Human Rights Act. Charters are actually nothing really new. They weren't new by the time John appeared. They go back thousands of years to King Cyrus, who founded the Persian Empire and ruled the lands currently occupied by ISIL. And he issued a code in 539 BC granting freedom of conscience to the Jewish tribes and abolishing slavery with the words, "I, Cyrus, king of the world." These charters were almost always acts of regal munificence. By 1215, this was not the case for King John. He had no claim to be ruler of his own kingdom, let alone the world. He was forced to the ancient Saxon meeting place at Runnymede, kicking and screaming, and the concessions we know as Magna Carta were wrung out of him. Most people are aware of the two famous chapters, 39 and 40, which declare that no free man is to be punished save by the lawful judgment of his peers, and I quote this beautiful sentence, "To no one will we sell, to no one will we deny or delay right or justice." Still, at 800 years distance, that sentence has the power to move. And I think Lord Bingham was right when he said it should be inscribed deeply into the walls or the entrance of the Ministry of Justice. Reading David Carpenter's book, I was struck, and this is an education to me reading these books around this subject, by the scope of Magna Carta. In a few thousand words, it's just a single piece of parchment, as we know. The contract between the king and the rebel barons addresses a huge range of subjects, quite apart from justice. Ecclesiastical, political, economic, taxation, social, and local government issues were all covered. And what comes through, I think, is the spirit of medieval civilization, the same sophistication that you see in the philosophy of Thomas Aquinas, the illuminated manuscripts of the time, and the early decorated Gothic architecture style of, say, Worcester Cathedral, where John was buried in 1516. We're going to have a similarly wide-ranging debate tonight. I hope and pray that either the audience or the speakers will touch on the following issues. Was Magna Carta a particularly Anglo-Saxon charter? Was it something asserting Anglo-Saxon virtues and qualities against the alien Norman culture? The charter, as you may know, was barely referred to during the Tudor period. It's not even mentioned in Shakespeare's play, King John. So how did it survive the 16th century to become the standard for rights and liberty in the 17th century, the basis of a Bill of Rights in England and America, the Declaration of Independence in America, the inspiration of a hero of mine, John Wilkes, and of course the Charters. Winston Churchill referred to the Magna Carta as the foundation of principles and systems of government which neither King John or his nobles dreamed. Is it too much to claim that Magna Carta was in fact the start of parliamentary democracy? Magna Carta is greatly revered in America, probably more so than here. In the 50 years between 1940 and 1990, there were something in the region of 900 mentions and citations of the Magna Carta in federal and state courts, and 60 in the Supreme Court. Yet the US has Guantanamo Bay, it has dragnet surveillance, mass surveillance without warrant, and our record is not a great deal better. We have secret courts, mass surveillance, and only a few years ago I remember writing article after article, first of all attacking 90 days without detention, then attacking 42 days detention without charge or arrest. I wonder this question as well. Are we in danger of letting the heritage industry swamp the bigger issues, both the historical and the current ones, surrounding Magna Carta? In 2 weeks' time, there's a London Global Law Summit in London, which says it will be a unique opportunity to explore what the future holds for global business and the rule of law. I have never heard those phrases put together before. Tim Berners-Lee wants a Magna Carta for the internet. So at the end of this, I will ask both all the panelists and you to say whether you want a Magna Carta, a new Magna Carta, a new constitutional settlement. So that's quite enough from me, and I'm going to hand over to David Starkey, who's going to introduce us to a bit of the history.
Do you want me to do it from here or from there?
I think there, if you're comfortable with that.
You said there, did you? Okay, fine, happy. University lecturers naturally stand. They expect lecterns, reverence, glasses of water. Okay, we have some of that at any rate. Now, typically, we've heard a lot of guff from Henry on the subject of Magna Carta. Magna Carta is a great theme for guff. We've just come, David Carpenter and I, from the Queen's robing room, where the great and good were assembled to worship 4 copies of a document that none of them could read and few of them could understand, and none of them ever apply. We drank Prosecco. Unfortunately, we weren't allowed to spill it on them. But, let's try and be a little more hard sense on this subject. Magna Carta is not a creation of 1215. The document of 1215 is abortive. It lasts barely a few weeks. In order to understand Magna Carta, we need to look at it as lasting at least a decade. That's the first thing. In other words, it is, to use a dreadful phrase, not an event, but a process. That's the first thing we need to remember. Secondly, we need to put it in the context of civil war, of treason, of intense conflict, without most of the time, I think, a single hero or a single guiding intelligence. The notion that you had some sort of great and good like Stephen Langton is tosh. He's not there. What we have instead is a typical product of chaos. It's also particularly important, I think, to realize that the reason Magna Carta survives is that eventually both sides of the political spectrum, John's opponents and those who were his diehard supporters, are finally to agree on a residual text. So if we just try to get some of those points there, I think it will help us. And the most important thing to remember is this is an awful warning of the futility of violence and revolution, of something which I suspect our American friends in this context find very hard to understand, because, of course, they tend to idealize it. Let's actually look at why John is in Runnymede and why John actually has to agree. John inherits England, or possibly murders his way to the throne, or whatever, in 1199. And within 5 years, he's lost the better half of a vast Anglo-French empire. He's lost his hereditary lands of Normandy and of Anjou and Maine. He then finds himself, curiously enough, never having paid, I think, terribly much attention to England. He'd always been much more interested in Ireland, spending a lot of time in England. And suddenly England has this immense slap of firm government. And not only England, but Wales, and not only Wales, but Ireland, and not only Ireland, but Scotland. And by the end of this period, John has established a kind of British empire, arguably the first British empire in which the power of the Anglo-Norman monarchy, instead of being projected across the Channel, is projected to the British extremities, Wales, Scotland, Ireland. He also accumulates, because of his pressure, is Henry VII-style pressure on the elite in screwing them financially. He accumulates a vast cash hoard, David Carpenter, I'm sure, will correct me, of the order perhaps of 120,000 more in cash, which is 3 or 4 times ordinary royal revenue. It's an immense sum. He then blows the lot on a single campaign. Remember always, constitutional change should be understood against a background of failure in war. It's one of the absolutely crucial things to comprehend. And he fails, he himself doesn't get very far in France, and his supporters are completely shatteringly defeated by Philip Augustus of France at the Battle of Bouvines. It's very interesting looking at the nicknames of the 2 kings. John is John Lackland, and didn't he lack it after that point? Philip Augustus is named by his first biographer, Augustus, on the grounds that he augments, that he increases his land holding. So John then has experienced shattering defeat. He's lost all his money. He finds himself literally exposed to his enemies in 1214, 1215. There'd been a parallel great struggle with the church, in which he'd also, as a desperate measure, had to surrender to that as well, the ending of the interdict and so on. And John then finds himself, as it were, without a leg to stand on, and the only leg that he had to stand on is chopped away when the barons managed to take London. So this is the king who's not simply lost the better half of his inheritance, he's also lost his capital. And he finds himself then confronting the barons, first in the Temple in London, in January 1515, and then, as it were, with accelerating pressure through the first 5 months of the year. And all the time, 2 things are going on. There is intense military pressure, which finally swings over into full-scale civil war. Secondly, there is the pressure to yield a charter, to give some sort of expression of liberties. And the idea seems to derive, you raise the question of the Anglo-Saxons. There are indeed histories of settlements between the king and their people, going back to somebody who I'm sure is absolutely in the forefront of all your minds, Ethelred the Unready, 2 centuries. No, we laugh. An idea of a settlement between the king and his people is there, and vague memories of Anglo-Saxon laws and so on. But all of these things are expressed in early 1215 by an appeal for the charter of Henry I, the coronation charter of Henry I. Henry I, of course, is the youngest son of the conqueror. He seizes the throne probably after having murdered his brother. So they were a bloody lot. And he makes a grand gesture towards his people in a Charter of Liberties. Now, Henry, like everybody else, quotes the juicy bits of Magna Carta. No one will sell, no one will deny, no one will delay justice. These were very, very splendidly described by John Gillingham as empty, high-sounding, and impossible to do anything with. Just one second. Right, you shut up for a minute. The greater the degree of guff in any piece of legislation, the less actual teeth it's got. And the key thing, why you go back to the Charter of Henry I, it's filled with dreary detail, as most of Magna Carta is. Magna Carta is a highly practical document. So you get this idea of the Charter of...
David, the fact of the matter is these sentiments have lasted 800 years.
They have. Sentiments are easy on the ear, and nobody needs to apply them.
But of course, they're not just sentiments, are they? They do have a solid practice.
The great
and I'm going to come to Dinah.
Henry, the great history...
I'm going to come to Dinah to ask us a little bit about the solid meaning in the law in the law from the 17th century.
But sorry, please, this is being silly, Henry. These clauses have no purchase at law at all. This is really important we understand, that the idea that Magna Carta establishes the rule of law in 1215 is absolutely absurd. Yeah. This is why we have constant struggles against the king, very quickly, why we have Simon de Montfort, it's why we have the struggles of Edward II, of Richard II. It's why in the 17th century the attempt at making Magna Carta fundamental law by Coke fails completely, and why the lawyers are completely useless at defending it. The law is the king's law.
David, have a sit.
We're going to ask.
That
is the history. That's the history.
Take a sit.
Well, the beginning of the history.
Rory, Dinah, would you like to talk a bit about what David's very contrarian view, that Magna Carta is not worth the parchment it's written on?
I don't think it is a contrarian view. I think actually it's almost become an orthodoxy for people to say, oh, Magna Carta is a bit of an irrelevant piece of guff. I don't think it is irrelevant guff. I think it's very important. Not for what it meant in 1215, but for the symbol that it became, and for the significance that it acquired as part of the common law. To give you what seems to me to be a good example, Blackstone's commentaries on the law of England, the classic 18th century text of English common law principles published in 1765. Blackstone, when considering the notion of absolute fundamental rights under the English Constitution, takes as his starting point Magna Carta, which he calls that great charter obtained at the point of a sword. And he identifies from Magna Carta 3 fundamental rights, which actually I think you can discern in Clause 39. The right to life or personal autonomy, the right to liberty, and the right to private property. Because what Clause 39 says is that you cannot apply force to somebody, you cannot exile them, you cannot take their property, and you cannot imprison them without judgment of their peers or without the application of the law. And from that principle, he identifies those 3 fundamental rights. And then he says this, he says, in order for those 3 fundamental rights to have any purchase, they must be supported by ancillary rights. And he identifies 3 of those as well. The first is the rights and privileges of Parliament. The second is the limitations on the royal prerogative and on the executive. And the third is the right of access to justice. And the significance of Clause 40, to no man will we sell, delay, or deny justice, is that encapsulates the notion of access to justice. So that what you have, I think, in Magna Carta is the kernel of 2 basic constitutional principles. Firstly, the rule of law and the protection of fundamental rights. And secondly, the need for access to court to support the rule of law. And that concept runs through the common law. You can see it in modern case law, important cases like Witham about access to justice, medical justice. And whether you're actually citing Magna Carta And I cite Blackstone's commentaries, and I've done it in many cases, and it gets much more purchase with a common law judge in many occasions than the Human Rights Act does, because Blackstone speaks to the breast of the judges in the common law. And the origin of those principles, ultimately, is a Magna Carta. And if you look at a case like the Al-Rawi decision that said that the common law would not tolerate secret courts, that is a passionate declaration by the Supreme Court of the importance of basic principles of open justice, which ultimately have their origin, not in Magna Carta itself, but in Magna Carta as a symbol as it's developed over the following 800 years.
Diana, I want you to come back about the application of Magna Carta now, any issues you have. But Rory, we must hear from you before David.
I'd really like David's response to that, and then I wanted to come back to the 13th century, if that's all right, Henry. Yeah.
Well, Diana and I, of course, are arguing in two completely different ways. She is arguing as a lawyer, which takes a text absolutely out of its historical context and plays it. I argue as a historian. Now, the view of Magna Carta that you get in Blackstone is, like everything else, a historical creation. It is a creation of 1689. What we have to understand is that the great problem with any set of rights is how you enforce them. Let's go back to Magna Carta, to what actually happens in between 1215 and 1225, and then your position and mine will connect with each other, because it's very important that we don't just shout at each other, but we know that we actually make the two positions connect. Right.
I hope that happens soon. Because we don't want the whole evening.
No, and I've
getting together.
No, but sorry, Henry. People have come to be informed. Let's try and inform them. What happens in 1215 is that the original Magna Carta, which did the things that you talk about, was also accompanied by setting up a committee of public safety of the barons, which behave in exactly the same fashion that every committee of public safety does. In other words, it was perverse, it was self-regarding, it was... No. Committees of public safety look at the original Committee of Public Safety. And that committee is abolished. And the Charter establishes itself in English law when those clauses, which have been the original device for enforcing it, are scrubbed. And the reissues of 1216 and 1225 completely omit that contentious material. The great question with Magna Carta then becomes, how is it to be enforced? And there are two answers. The first is that the deal, the Charter as it's issued in 1225, is a contract. It's reissued in 1225 in return for a grant of taxation. It is, in other words, the origin of Parliament. It's the idea of a grant of taxation in return for a redress of grievance. And the great development of English law is the idea that the effective control on government is parliamentary sovereignty, which, of course, Blackstone is the great hymn to parliamentary sovereignty. There was, however, this does not establish itself in the Middle Ages at all. The idea that that the king is subordinate to law is talked about by a few idle theorists. It is not put into practice. Just one second. No. It is not put into practice until the idea... Please, I will make one point and then I will shut up. It is picked up by Sir Edward Coke at the beginning of the 17th century in the Petition of Right, who has the same set of views that you do. He wants to make Magna Carta fundamental law that will be above Parliament and above the king. And it fails absolutely, and the judges of the 1630s do not enforce it, and it takes a civil war and another revolution in which both right and left agree, that's to say the revolution of 1689, which gives us the, as it were, reenactment of Magna Carta, the Bill of Rights and so on. But ladies and gentlemen, subject here to the absoluteness of parliamentary sovereignty, which means we're not defended against Parliament, we may be defended against the king, and if a Parliament is foolish, as Parliament so often is, we've no protection. And America goes in completely the opposite direction.
At that point.
At that point,
we're going to Rory's too.
But it takes up the idea of fundamental law directly from Edward Coke. So you're really an American.
Okay. This is really more
and it doesn't work either.
This is, Dave, more of a question to you, or maybe to David Carpenter. One of the strange things as a member of Parliament dealing with this is that clearly there's a feeling in Parliament, or there's a feeling in the British Constitution, that the Magna Carta is at the heart of our practice. And if you were a 19th century member of Parliament, you referred a great deal to this text. It would be a very normal thing.
And you repealed it.
And indeed, if you're Gordon Brown, even speaking...
No, the 19th century repealed most of it.
Gordon Brown, in his adjournment speech last night, I was in the House of Commons last night, again, massively evoking great traditional constitutional liberties going back to 1200. Now, the problem, and this is why I want to bring in the historians in relation to a politician, is that as an amateur looking at all this, as a young politician, what you really notice is an attempt by people like David to make the 13th century seem seriously weird, a seriously alien world. So we have a sort of vision that it's almost impossible to connect to these people, that the barons are a kind of rugby club, that their views are bound up with crusades, with extraordinary half-magical beliefs about the power of body parts, that half of this is taking place in the context of papal excommunication, that all these people are not really English, they have strange international lives, they travel to Palestine, they speak French, their notion of nationality is just evolving. John's brother Richard writes this wonderful poem when he's captured, in which he talks about his English friends, his Norman friends, his Poitevin friends, and yet we're not quite sure what any of these things means, because when he returns to Britain, he has William the Lion of Scotland walking in front of him with a sword, and what exactly is this relationship? And yet, and this is what I want to try to bring David in on, and yet somehow coming from Afghanistan to Britain, you get a sense of something very modern happening. When you go through the Great Charter, you see a whole series of stipulations about what the king shouldn't do. And it's those very concrete things. The king shouldn't be able to take my cart without paying a just price. That strikes me as somebody who's been dealing with the collapse of law in Afghanistan as very, very relevant to real lives, and something that today, still in countries like Afghanistan, we're really struggling to achieve. In Helmand, you can't, as a landowner or a villager, really guarantee that somebody's not going to come along and nick your cart without paying you for it. So what I wanted to sort of bring maybe the two Davids in on is that question of that connection. How do we connect? And that's also why I thought Dinah was so romantic and moving, because she seems to be able to move beyond this 800-year gap, a gap that's bigger than the gap to Agincourt, back to this alien, weird world of people that we could barely recognize. Huge, muscular people waving swords around with strange beliefs about Jerusalem, and yet she feels it's something in her current practice. And that I found profoundly moving and exciting.
I'd like to bring in David Carpenter. I don't know if he's got a microphone. Are you mic'd up, or if somebody could bring David a microphone? David's wonderful, but makes, among other many interesting observations, the difference. He points out how many times the word land, the idea of law of the land, appears in Magna Carta, something had never occurred to me. And so, apart from it just being a medieval creation, it seems that it actually was harking back to some sense, some mythic sense of a land that had justice before. Is that right, David?
Yeah, well, thank you. Well, on the way here in the taxi with David, I said I'd try and say everything he said was bonkers. But actually, I don't say that, because I thought I agreed with a lot of what David said. But I would pick up 2 points of Rory, that I think the Charter survived and was a success for 2 reasons. One was that it asserted a universal principle that the king was subject to the law, and I'll come back to that and what David saying that had no effect. And secondly, it did deal with very real issues, very, very important issues for people at the time. And you're so right about the seizure of corn, carts, everything like that. These are really important issues, and that's why the Charter it really gripped the hearts and minds of everyone. Now, 2 points about what David said. David said the Charter in the short term was a failure. That's true in a way, but also not true, because actually by the end of 1215 it was hugely well known, and that's because it had been sent to all the cathedrals, and also recent research shows lots and lots of unofficial copies of the Charter were circulated. So it wasn't just a symbol. The detail was very well known by the end of 1215, and that was why it was revived. Now, David scoffed at the Charter and said it had no effect. And of course, that's exactly what lots of Englishmen in the 13th century said, that the king breaks the Charter, it can't be enforced. But actually, if you look at the operation of kingship before and after 1215, the Charter does seem to be a real watershed between lawless and lawful rule. And by far the greatest indication of that is that whereas King John seized people's property without any lawful process, charged huge sums of money for people to get rid of his anger, to recover his benevolence, so that John would charge in offers of money every year, something like £25,000. Later kings, Henry III and Edward I, that all disappears. There are no offers of money to recover the king's benevolence. There are no arbitrary seizures of property under Henry III, Edward I, at anything like the same degree.
Until Henry VII.
Yeah, well, of course, I can't answer for your period,
this
and
is-
that's
this
where
is
the
the problem.
Tudors...
I'm going to stop you there.
That's where the
because I want
Tudors
to
all get it
question-
wrong.
I'm going to stop you.
Just a second.
I'm going to stop
Under
you
Henry
because
VII, you have a complete revival of the rule of John, and to a greater extent. Henry VII is 4 times as effective as John and doesn't lose his throne
Right.
and doesn't have to reissue the
Now,
Charter.
we're going to have some questions from the audience, so we're going to have a break at least for questions from the audience. So please, I find it difficult to see. Has anyone got any? Yes, I think, would you just say who you are? Because I think you, yes, that's you. You with the tie. You with the...
I'm Stuart Weeder.
Yes.
I'd like to ask the panel whether they think that the European arrest warrant, by which anyone in this room can be whisked off to Greece or Romania or any other European country, EU country, to be tried for something without their having to produce a shred of evidence that I may be guilty or any of us may be guilty of it, whether that is in any way consistent with Magna Carta.
Great. Now, we'll keep that in our back pocket. And we will ask if there are any more questions. Any more? Yes, there's one here. I think it's Joshua Rosenberg, is it? Yep.
If we hadn't had Magna Carta, would we still have had the common law and Blackstone and human rights and everything that Dinah attributes to it?
Okay, so would you like to all three address those questions? And if anyone else has got to stick up your arm vigorously, because I...
Well, let me just very quickly, because this is stuff that David and Dinah are much better on than me, but let me just have a stab at this. I mean, one of the things that strikes me as interesting about this weird charter is the way in which it's then reissued in places like Normandy, the way in which people take this idea of English liberties and use it as a way of bullying French kings. I mean, and I do feel, obviously I have to feel as a politician, that the acts of individuals, even accidentally, do have long-lasting historical effects. And I find it difficult not to feel more romantic about it than David does, and to feel well, I mean, I feel actually the great hero of this, maybe, and again, I'm going to be contradicted by David, but is in a sense for me William Marshall, who reissues it in 1225, and who is the most splendid figure of an age.
1216.
Sorry, 1216. 1216, thank
He's
you, David.
dead,
Thank
long
you.
dead by
1216 reissues, in order to bring the young boy up. And I think Marshall represents something which can't be reduced to a sort of brutal, baronial thug, but instead somebody who speaks across the age of a man of honour. But anyway, I'm going to hand over to Dinah.
Dinah, would you
Yeah.
just like to think
Yes.
about the European... Give us an answer on that.
Stuart, last time I met you, you asked me exactly the same question with reference to the Human Rights Act. And I'm going to have to bitterly give you the same answer, which is, unfortunately, there's nothing in the European arrest warrant that's contrary to Magna Carta, because the European arrest warrant is a legal instrument that's been enacted by Parliament in primary legislation domestically, and therefore complies with the rule of law. Now, you can argue about the policy, but unfortunately, it's not an unconstitutional item. It's a political question. But can I just address Joshua's question briefly? Because I don't think it's inevitable that the common law develops. I don't think it's inevitable that you have a particular legal culture in Britain. And I think that the legal culture here is very different from that in continental Europe, profoundly different. And part of that is because of the sense of a continuity of the building up of a corpus of common law that goes right back to the aula regis in the 12th century. And I think that partly because although we had revolutions, some of them were abortive and they didn't have the same discontinuity that you have in France, for example. But sorry, that was obviously controversial.
Wrong.
I think
not
okay.
controversial. Wrong.
Okay. Well, they're on their 5th republic, so there must be some difference there. But and we still have the same monarchy. But I think that the way that the law is expounded by judges here contains within it a sense in the judges of a continuity in history. And you can go to court in some cases, and you can engage a judge in hundreds of years of legal history. Just to give you an example, I did a case about whether or not SIAC, the Special Immigration Appeals Commission, which tries terrorists or deals with terrorists and deportation matters, whether that was subject to judicial review in the High Court. And Parliament had said that SIAC is a superior court of record. Immediately raises a constitutional question. Can the High Court supervise by judicial review the acts of a superior court of record? All the textbooks said no. We went back and we looked at the relationship between the Court of King's Bench and the ecclesiastical courts and other courts going back to the 12th century, and we demonstrated that you could. And the divisional court ruled that the High Court could judicially review a superior court of record, and that was upheld in subsequent cases. So, I don't think it is inevitable that the common law develops as it has, and I think that Magna Carta affects the culture.
David, I wonder if you thought if Magna Carta hadn't occurred, if that charter, if that peace treaty hadn't occurred at Runnymede, we would have invented it anyway. Was it inevitable?
Let me answer two things. First of all, it has simply confirmed to me that our judges know nothing of law. The idea that anybody would have called in the Middle Ages, anybody would have called a court, a church court, a court of record, is simply astonishing. It was a totally separate system of judicature. There is a brief moment between the Act of Supremacy and the abolition of the church courts when you could just about stretch that. So, again, the shattering ignorance of people operating a historical system.
You're wrong on this one, David, but it's not the moment to get an argument about
it.
But
Let's go back to Joshua's question. In fact, I agree completely with what Diana said on this and what you said. This indeed is a historical system of law. It would not be the same without Magna Carta. Magna Carta, providing you look at it in the span of from 1215 to 1225, is absolutely fundamental. The point that I'm trying to get at is we mustn't do what people like Diana do and read some kind of, you use the language, you use all this biological language, germination and whatever, biological determinism. It's lethal. What then happens? The whole process is subject repeatedly to historical contingency. All ideas are products of time and place. It is perfectly clear that despite the endeavors of the 12th and 13th century jurists like Bracton, despite the endeavors of Fortescue in the 15th century, Henry VII could drive a coach and horses through this entire process. It is equally clear that Charles I was supported overwhelmingly by the bench. Lawyers were totally useless. Lawyers were useless under James II. It's only once the rules of the game are changed decisively as the result of a highly specific concatenation of circumstances in 1689 that what you describe is possible. And if we lose that sense of historical contingency, if we go back to the 19th century and we argue in this sort of slow evolving growth, I compared Magna Carta to a kind of national 800-year bowel movement. We ignore how things actually happen, and we make the terrible mistake of taking the guff of things like universal human rights seriously, whereas in fact we should be interrogating it vigorously. Anything that claims to be outside specific time and place is unreal.
I'm comfortable coming in on this.
Unreal.
What do you mean by the guff of universal human
I
rights?
think
Because
they are
there I am going to challenge you.
They're guff.
No, the notion of rights is not...
Everything is specifically culturally conditioned. In so many cultures, the notion means nothing at all.
No, David. Rights is based on a fundamental principle of rationality, which is the equality and the dignity of individuals.
But then many cultures don't embrace that. That's a completely culturally specific notion.
And in your,
it's a mere product of the Enlightenment. You're just a sort of
in
little
your words,
18th century chap.
and in your words, David, they're wrong.
Well, you may think that. They will probably think you're wrong. And unfortunately, there's no means apart from force by which you can arbitrate it. As we tried in Iraq. We tried exporting the Enlightenment by force in Iraq, and look where it got us.
Now,
or
I just
indeed
want to-
Afghanistan.
On this very issue, I want to bring in Lord Folkes, who's Minister of State and Justice. Do you think there's such thing as rights? And would you go along with David Starkey? I mean, certainly your government sometimes seems to behave that way.
No, well, I knew that our government was going to be criticised. We don't actually have clauses 39 and 40 over the Ministry of Justice portals. But in promoting the Global Law Summit, I was sent all over the world, places like Kazakhstan, Kyrgyzstan, China, not obviously countries that respect human rights. And I told them about Magna Carta, clauses 39 and 40, and students there were moved. And it may be that their detailed historical context was not fully appreciated by these students, and certainly that may be the case. But it does have resonance. It's rather unusual for lawyers to be criticized as romantics. They certainly have a profound regard for precedent, as we've heard. The fact that we find it difficult to define rights does not mean that we shouldn't be trying to do so. And we can argue exactly how best they're reflected, and we can say that a level of abstraction sometimes doesn't help. But I think Magna Carta does have resonance now. It's not just that it's 800 years since it came about, and I think that it's not just the students in Kazakhstan and China who have some appreciation of it.
Rory?
Yeah, let me just come back to David on this for a second. I mean, the idea of rights, which you're presenting simply as a historical artifact, is a much more sophisticated product of analytical philosophy, and indeed of the Enlightenment. In other words, if we argue that, let me give you a theory of rights. Let's say that we were to say that someone has a right is to say that anyone treated in a certain way is wronged, and that their possession of that right is not relative to the costs or benefits of upholding it in any particular case. So that right might be abrogated, but their possession of the right is not relative to the costs or benefits. In other words, it's an assertion of something other than a consequentialist worldview. It's asserting that you could possess something as an individual which cannot simply be suspended for the purpose of some temporary benefit. Now, that isn't simply something which has emerged by accident, peculiarly in Britain or in France or the United States. It's the product of an entire theory of equality. And even though, you're right, there may be societies, although they're getting increasingly few, who don't accept that
Russia,
view.
China, the whole of the Middle East, much of Africa, large parts of South America.
Well, David, actually, interestingly, very rarely in those countries would you find somebody attempting to philosophically defend an alternative view.
They may well
be acting in a way that abuses those rights, but it's very, very rare to find somebody putting forward.
All I'm really trying to say is that doctrine of abstract right, the way you present it, is religious. It is we're being required to believe 4 impossible things before breakfast. The doctrine of universal human rights is very similar to a doctrine of salvation. It's ahistorical, it's in one sense. And then in another sense, of course, it's an utterly specific creation of a particular moment of the 18th century.
David, the reason why it's successful and will remain is that it's not, and will remain, and more people will accept it, and indeed in 300 years' time, everybody will accept it, is because it isn't religious. It's based on a much more simple idea, which is the existence of other people.
Oh, I love politicians.
Diana, I wondered how you felt Magna Carta. Do you feel that Magna Carta is in the breast of the politicians we have today? Do you feel that they're aware? Do you feel they're
It's a
Magna
brittle
Carta
parchment.
compliant? Do they think of Magna Carta compliance when they're legislating? I mean, we have, as I mentioned in my intro, quite a lot of examples where that has not occurred.
Yes, I mean, you've given examples including secret courts or mass surveillance, examples where there is a tension between civil liberties on the one hand and national security issues on the other. What concerns me at the moment is something much more basic, much more fundamental, and much more closely related to the core of Magna Carta. What I said a little bit earlier was that one of the fundamental points that comes out of Magna Carta is the idea that you have to have access to justice, that if you can't enforce your rights in a court, you have no rights. And in that sense, David's right, that universal human rights are guff if they can't be enforced.
Precisely.
And that's why what interests
Precisely.
me is not so much universal human rights, but British civil liberties that can be enforced in our courts. And what concerns me at the moment is that this government is conducting a sustained and ideological attack on access to court. And it is passing almost without notice in the national media. I want to give three examples of it. First of all, the so-called reforms to legal aid. Secondly, the proposals made 2 weeks ago massively to increase court fees, which have passed almost without comment. And thirdly, the new legislation which will restrict access to judicial review. Firstly, in relation to legal aid, as many of you will know, 2 years ago, the government removed legal aid from most forms of civil litigation. Whole areas where previously legal aid had been available, it was removed from, including almost all family law cases, except where there is recent evidence of domestic abuse. This has resulted in far greater numbers of cases where people are litigants in person, cases taking much longer, and appalling situations arising in courts. A situation a few weeks ago where a father was seeking access to a child, where the mother said that he had sexually abused the child, where because no legal aid was available, the judge was contemplating a situation where the father would have to cross-examine his own child on the truth of the mother's allegation that he had abused that child. That's an intolerable situation to have in any court, and it is the direct result of government policy. And the Lord Chancellor, Christopher Grayling, sent leading counsel into that court to argue that it was the father's choice to be unrepresented because he had a disposable income of £10,000 a year. I'm not making this up, it happened. So that's the first thing, legal aid. And the Public Accounts Committee yesterday produced a report in which they pointed out that the Ministry of Justice had introduced these reforms without first taking the trouble to work out whether the money they would save would in fact be saved, or whether there would simply be knock-on costs in other departments because of the physical and mental harm done to people who would no longer be able to get access to legal advice. And the comment of the Public Accounts Committee, a cross-party committee, was that the Ministry of Justice now has no idea whether it's actually saved any money from these reforms. So that's the first. The second, and I want to be quick about this. Let me just deal with the three, and then I'll stop.
Be quick with the third, and then I'm going to come to Rory, because I
the
feel
second
he
is
should
court
answer his
fees. Because, of course,
So
the removal of legal aid.
We get the point.
Okay, the removal of legal aid.
We
means
might
you
have said-
it's okay, you've had your
We
say.
really do get
And
the point.
With the removal
Quickly, and I
the
think
removal
you
of
need
legal
to
aid
move on.
means
Yeah.
that you can't get a lawyer, but you can still go to court. But what the government is now proposing is massively to increase the fees for bringing an application to 5% of your claim, up to £10,000.
No.
Now, so if you have a claim for personal injury or clinical negligence, you could be charged up to £10,000 just for bringing your claim. So even without a lawyer, you can't get into court.
Right. Okay,
Sorry.
Rory, would you like...
Yeah.
What we're going to do is we're going to have Rory's going to answer that, and then perhaps more questions on...
Yeah. I mean, I guess I'm not really going to provide a very satisfying response. Firstly, I defer enormously to Dinah on this stuff. I'm not a legal expert. if you really want a government response, I'm afraid there is a government minister here from the Justice Department sitting
We'll
there.
get it.
I would say there are two things that struck me, though, with what she said. I mean, the first thing, obviously, is I do slightly disagree with her with this idea that rights are guff without enforcement. I think we have to accept that rights are fundamental and pre-exist the question of enforcement. And if we try to reduce rights simply to cultural practice, which is what David and Dinah both seem to be agreeing to do, I think we move into a rather dangerous world. The second thing where I do agree with her, and I think this relates back to Magna Carta, is the idea that rights in a constitution are not simply about abstract principles, but what is in the Great Charter itself, which is the questions of cost of justice, which Dinah just raised, and process. The fact that quite a lot of the Great Charter is about process is quite an important insight, but that's really me moving into history. And if you want to get into a debate about legal aid,
Quickly,
yeah.
Lord Folkes.
Yeah.
Does anybody want to say a very long rejoinder to this?
No.
But the fact is there have been cuts in legal aid. We know about that. Some of them are definitely causing hardship at the edges. However, there have to be some cuts, and the next government, whatever colour it is, going to continue to make modifications to legal aid. The judges are doing their best to deal with litigants in person. But I'm absolutely clear that there are some cases where there are hardship. As to judicial review, the government's reforms have been mischaracterised. They're extremely modest. Judicial review has exploded way beyond the scope in which it had originally played an important part in challenging government activity. And all that's happened is some sensible modification of an explosion of judicial review has eventuated. Of course, that's a rather boring answer, but it happens to be an accurate one.
Fine. Now, any questions? I'd love some more contributions from you, the audience. There are people up there. Remember, I can't see you. And there's a microphone, fixed microphone up there for anyone who wants to come and shout down at me. And meanwhile, there are roving mics. So anyone wants to talk about or ask questions about, we've got one up here. I can't see much, but okay. There's a guy in the white shirt.
Hello, Frode Hegland. I heard William Marshall mentioned earlier. I'd like to know more about his role, because from my understanding, he made Magna Carta real, not to defend people, but to make sure that kings could still be around.
Perhaps David Carpenter would like to answer that, would you?
William.
We need another mic. Oh, gosh.
There we are. That's fine.
While he's getting the mic, let's have a quick question from you.
Yeah, I'm Claire Gerarda. I'm not a lawyer. I'm a doctor, and I was struck by the comment you made. Sorry, I've forgotten your name. About we have to have laws that are based on fairness and not on the culture. And I'm sort of reflecting on yesterday's collapse of the CPS trial for a doctor against a female medical mutilation, genital mutilation. And in fact, doctors now are actually not subject to the Human Rights Act in terms of we are found guilty until proven otherwise, we are suspended, all sorts of issues around the medical profession that we often feel, and as somebody that leads a service for sick doctors, that it's trial by the Daily Mail or equivalent newspaper rather than, as I suspect you three earnest people will think, which is trial by the rule of law, which is the way that I want to. So it's a statement and also a question.
Statement. David, would you just like to reply about William Marshall?
On William Marshall. I mean, I think he did play a profound part in the survival of the Charter. It was he and the papal legate who issued the charters of 1216 and 1217, without which the Charter wouldn't have survived. Where I would qualify his role is that the Charter of 1215, 1617 was granted to free men. So the great majority of the people in this room would not have been free, and they would not have benefited from it at all, or in a very, very minor way. If you're looking for someone who actually did have a sense of rights for everybody, I think you should go not to William Marshall, but to Archbishop Langton. And the Charter of 1225, which David very rightly said, has a status the 1215 Charter never had, because, as David very rightly said, it was conceded freely by the king. It wasn't coerced, it was in return for a tax. That has a new preamble in which it is granted to everybody, So the 1225 Charter is quite different than the 1215 one. The 1215 one is only for the free. The 1225 Charter is for everyone. And I think that was Archbishop Langton's work. So if you're looking for a hero, not in negotiating the 1215 Charter, I don't think he played a part in the build-up baronial demands. If you're looking for how the Charter survived, you should look to the Church and you should look to Archbishop Langton.
Of course,
And
you
just
make the
a
point.
quick-
You make the point in your
Henry,
book.
sorry,
you make
just-
the point in your book that it hardly mentions women. It's only one. Is that right? Only one place does
The
it.
Charter reflects, obviously, the lack of a public role of women.
Yeah.
Though it names 39 men, it doesn't name a single woman. On the other hand, the famous clause, no free man is to be outlawed in prison. But there was a sense in 1215 that man homo, the Latin, did embrace men and women. There was a sense that it meant human being. On the other hand, if you go on with that clause, it says no free man is to be outlawed in prison save by lawful judgment of his peers. Well, women would have to rely entirely on men to give that judgment because women were not on juries, they didn't give judgment in court. So the clause does both reflect something for women and also the lack of a public role of women. The most important clause for women probably in the Charter is that preventing women from being, widows from being forced into remarriage. And that has been seen as a sort of step on the emancipation of women. And again, for David, that did have a real effect in the 13th century.
Just quickly, your point about William Marshall. William Marshall, I think, is the Duke of Wellington of the early 13th century. He's an upright military chap, fundamentally conservative, but a fair dealer. And his great contribution in 1216 is he does not invoke laws of treason. That the settlement, what is astonishing about the settlement of 1216 is that it incorporates the opponent, pardon?
1217.
Yeah, but it incorporates the opponents of the king as well as his supporters. So there is none of the kind of purges that you get later on. There is, despite this intense debate, it's very English. Both parties finally agree and shake hands. And if you look in English history, everything that becomes permanent is finally agreed by right and left. This is exactly what happens with the revolution of the 17th century. You know, you get this extreme revolution of 1649, and then this middle ground of 1689. It's exactly what happens with the Reform Act. The Reform Act of 1832 only really works once Disraeli picks it up. Once Disraeli picks it up in 1867, and at which point it becomes common ground.
David, can I pick you up on just this very English point? I mean, in what sense are they really very English? I mean, Langton's been sitting around in Paris for 20 years.
But they're inventing Englishness. They're constantly calling themselves English. Of course, the opponents of the king do the unforgivable thing, which is to bring in a Frenchman. Remember, they are traitors. They try to bring in a French prince, who, interestingly enough, does not offer to renew the charter. It's the strangest thing you do, you know. You bring in, because you hate John so much and then claim to hate William Marshall, you bring in a French prince without actually making him agree to issue the charter, which is another reason why William Marshall, as a shrewd politician, does it. But all of this, you see, England starts to invent itself once you lose Normandy. And once you actually have to focus primarily within the British Isles, once you also have to choose allegiance, something that William Marshall was very reluctant to do. Until you lose Normandy, everybody's got cross allegiances because people have got multiple feudal allegiances to the King of France, to the Duke of Normandy, to the King of England, to whoever. And suddenly, and it's no accident, and David knows infinitely more about this than I do, I think it's no accident but that by the time you're getting into the 1220s, you're starting to use treason. Because England is starting to become a self-defined entity with a single pole of allegiance.
Now, I want you a little later on to vote on this question, to stick up your hands on the question of whether we need a new charter, a new constitutional settlement. And I wonder, Diana, whether you could, with your knowledge of the law and your considerable work for civil liberties, whether you could address that now.
I think that David has put his finger on one of the key issues here, which is how do you have any notion of fundamental rights when you have untrammeled parliamentary sovereignty. And it's the essential tension that exists in any attempt to form a British constitution. And it's the underlying reason why there is so much stress and tension between Parliament and both Strasbourg, the European Court of Human Rights, and the Luxembourg Court under the EU. Because both, as a result of both the Human Rights Act and the European Communities Act, there is some form of modification of parliamentary sovereignty, different in each case. EU law trumps domestic primary legislation. You can go to an English court and you can rely on European legislation to trump a United Kingdom Act of Parliament. The Human Rights Act is actually a much more subtle and nuanced piece of legislation. And in a way, it's odd to me that it attracts so much hostility from this government because it's much more conservative in its outlook. It preserves parliamentary sovereignty. All it does is that Parliament instructs the judges to interpret legislation compatibly with human rights as far as possible, but if not, they can make a declaration of incompatibility, but the legislation remains in force. And by the way, the Human Rights Act does not make the British courts subservient to Strasbourg. It only says they have to have regard to Strasbourg judgments. So one of the oddities about the hostility of the Human Rights Act is that actually the Human Rights Act already gives most of the things that the government says they want. Now, the Conservative Party now has, as part of its manifesto, a commitment to repeal the Human Rights Act and replace it with a British Bill of Rights. When you look at the substance of the rights in the Human Rights Act, most of them are common law rights anyway. You can argue around the edges, particularly about Article 8 and privacy, but most of the fundamental rights in the Human Rights Act are familiar to us at common law. The really interesting question is, how will a British Bill of Rights deal with the tension between fundamental rights and parliamentary sovereignty? That, I think, is the key question. I don't know what the answer to it is. I'd be interested to know what Lord Folkes thinks about that. And I note that Lord Folkes did not mention the increase in court fees.
Okay, let's Paul Ed. Let's ask Rory about the tension between the rule of law, rights, and parliamentary sovereignty.
Well, I suppose a couple of things. I mean, I think the first thing is that the other reason why Britain should be very proud of the European Court is that we helped create it. And it has been something. I mean, one of the things that makes me embarrassed about this European Court issue is it seems to me that Britain rather enjoyed the European Court through the 60s and 70s when it functioned as a way of telling off people in Greece and Spain and telling them they weren't treating people as well as we did in Britain, and only began to get worried by the European Court when the European Court began turning around and saying that we needed to give our prisoners voting rights and things of that sort. So I'm quite sympathetic towards the European Court. I think the bigger issue around parliamentary sovereignty is the fact that we don't actually have a constitution in the American sense. We don't really have a difference between constitutional law and normal law. I went through this in my own life very soon after I joined Parliament, where I discovered that Parliament was proposing to abolish the House of Lords on the basis of a simple majority in Parliament. In other words, the government whips were standing outside the chamber and trying on the basis literally of a 50+1 vote in Parliament to abolish the second chamber. It's completely unimaginable in any country in the world. Any other country, the idea of a constitution is to protect the people against the government and the Parliament. The idea would be that in order to do that in any other country, you'd need some special procedure. You'd need a 2/3 majority, you'd need a referendum, you'd need an election in between. So I would say the first thing I'd really like to do in Britain, and the inspiration I'd like to take in a very, very indirect and bogus fashion from Magna Carta, I admit it's indirect and bogus, would be to try to introduce procedures in the House of Commons in order to ensure that you can't simply do things like abolish the second chamber on the basis of a 50+1 vote in Parliament, and that we need to move towards some respect for the Constitution which used to exist on the basis of all this sort of wonderful, romantic sense of our ancient Constitution, a Parliament that used to be filled with lawyers who were very sensitive to the Constitution, deferential to the Constitution, has been replaced by a culture which is so ahistorical that we're perfectly capable of simply waking up in the morning with no forms of cultural historical constraints and tearing the whole thing up. And I think once we enter that world, we need much, much deeper impediments to parliamentary action over the Constitution.
David, would you agree? Would you?
I would completely agree. I mean, the great problem, without being too party political, is the Blair government. Yes. With its notion, it's the notion of the year one, of starting from scratch, of all history being bunk and junk and something that you can forget. I mean, the process of legislating a new parliament for Scotland, at a whim, simply as a piece of party political advantage. And we're now reaping the shocking rewards of this process. Yes, we do need, I think we need a fundamental, radical new constitutional settlement. I will go much further. I think that the idea of parliamentary representation, which emerges as a direct result of 1225, further formulated in 1265 by de Montfort's Parliament, that notion of representation was the latest wheeze in the middle of the 13th century. It is looking ever such a tad frayed, 750 years later. I would also like us to start looking much harder at what the real substance of Magna Carta was about. The principal concern of Magna Carta is not legal process, it's property. The entire anchorage of Magna Carta is property. The reason for the success of Britain and the West is the security of property right. We have become utterly frivolous on this subject. You've been mentioning all these breaches of legal rights. What about the right of the Exchequer simply to take money from you before a court or a quasi-court has actually heard that it's decided that it's due to you? This is monstrous. John would have absolutely loved it. It's exactly the kind of thing that he did. And have many lawyers agitated about it? No, because of the general human rights left in nature.
Actually,
of the bar.
there's a judicial review of that
Good.
Currently underway, so I'm afraid
excellent.
you're wrong about that too.
It'll be very interesting to see what the lawyers say about it.
Now, I'd very much like to have questions and views on the question of a new constitutional settlement. Not just a new Bill of Rights, but a constitutional settlement which would incorporate a Bill of Rights. So it'd be Magna Carta Point 2 or something or other. Go ahead, please.
Thank you very much. Joanna Malins, I'm a solicitor. Can I say that one of the great glories of this country, legally speaking, is that we have an unwritten constitution which bends and doesn't break, that's the point. It bends and moves in accordance with the needs of the time and historical development. Now, one of the things which we have had thrown up in this country is the tension between, as Diana Rose was saying, between the judiciary and the legislature, but that's to do with the separation of powers. We've got the separation of powers, which is crucial. We've got the executive, the legislature, and the judiciary in this country, and they interact in this very malleable, excellent fashion. And furthermore, because we have an unwritten constitution, we're able to have as part of our constitution all these ancient things. Dr. Starkey would know, things like the Clarendon Code, all these ancient pieces of, sorry, I can't quite quote well.
Do you know what actually you're talking about?
There are so many things which have come down the centuries, which are still part and parcel. Maybe I'm wrong, but they're part and parcel of things which we still use and we still need. And I wouldn't want an American system where the Supreme Court could come in and overrule what Parliament's done.
But of course, a sovereign Parliament can then legislate against the rule of law, which is really Rory's point, isn't it? I mean, it's a gentleman's agreement that you're relying on, and you're hoping that that lasts. And people like me, I speak now not neutrally, would say that's a worrying thing.
Well, I can see that. Can I make
anyone else going to have you've made a wonderful point there. Let me just... Yeah, super. Okay, well, I can't see... there's a guy waving his order paper. And I think his name is George, if I'm right.
Right, George Kershaw. Yeah. Could I ask about the right of the state to defend its own secrets? And I suppose in this context, Snowden is an interesting question.
Who would you like to talk to? What about Rory? Would you?
Well, yeah, but you. I mean, you know more about this than anyone else. I mean, I don't know why... Are you not allowed to speak?
Well, I am allowed to speak.
We give you permission. Yes,
Thank you. That's what I was waiting for. Well, if you want my view, it's certainly the state should have secrets, and certainly the state should be able to defend itself. But I also think that in a democracy, one of the things that we have, prior to an election particularly, is informed consent. And I think any democratic public should be given as much information about the way they're being monitored as possible, because then we can say whether we like this form of government or we can choose somebody else. But that's my view.
Can I say
Good.
And I've had a lot of experience in cases where national security has been used as a reason to withhold evidence from a party or to withhold evidence from a court. And I've seen many times that when the evidence has finally come out, there's been no national security implication at all. But too often, what the evidence actually does is to embarrass the security services. And I think there's a big problem of a confusion between what's damaging to national security and what's damaging to MI5. And I think sometimes those two are seen as the same thing, and they're not.
Very good point. Now, there are lots of arms stuck up. There's a man in a blue shirt who's going to get a chance. But then I'd like some women too. Would you? Yes. No, you're not a woman. Go on, go.
Yeah, so where David talked about rights and charters coming out of either revolution or war, or civil war, whatever, how might a new settlement come about, especially when so many politicians seem to think that our liberties can just be taken away little bit by little bit, and indeed they get away with it?
Okay, well, let me take that. I mean, I think that one of the fundamental problems for somebody like me that's very obsessed with constitutional issues is that basically the public doesn't seem to be that interested. I mean, if you were to ask people to list their top 20 priorities, the Constitution very rarely features. And so colleagues quite understandably say to me when I bang on about this kind of stuff, well, really, Rory, I mean, if you talk to people on the doorsteps, they want to talk about the economy or they want to talk about the NHS, but they're not really very interested in constitutional reform. There is another problem, of course, which is a turkeys for Christmas problem. I mean, if, for example, we were to propose that 650 members of Parliament were too many and 100 would do us perfectly well, it might be quite difficult to get that legislation through the House of Commons. But I think the final thing is that in order to really get this change, we're relying on you. I mean, we really need to get a popular movement going. And one of the difficulties with this is, where does the legitimacy come from? Where does the energy come from? How can I actually lead a party through an election saying, we want to bring constitutional reform unless I can bring you with me?
Well, what may very well happen, of course, is that the next election could well produce a crisis of ungovernability. It seems to me that we are quite likely to face a position in which it will be impossible to construct a working majority in the House, or that you will construct combinations that are so manifestly outrageous that there will be widespread popular discontent, particularly in England. I think there's just one other point on this question of rights. What Magna Carta is about, and David's book demonstrates this magnificently, is this sense of land, terrae, the land of England. The great problem with the European Convention on Human Rights is that it's not British. It's not felt to be English. Ever since the reign of Henry VIII, there's been this passionate sense that no foreign body has any right to impose law on England. And, you know, there is a catastrophe that it's the Treaty of Rome, when we've had 500 getting on for 500 years of passionate anti-Romanism. I mean, as I always say, there's a direct line from Henry VIII to Nigel Farage. Henry VIII is they all had foreign wives, even had a German wife. And there is a very, very real sense. England is uniquely sceptical on Europe. And I think this is it's not simply the longevity of English institutions, it's this sense of the foreign beginning in the Channel. But there's also another sense that the way in which the systems of law of continental Europe are radically different, the way in which words change their meaning as you go across the Channel. L'intérêt public is something completely different from the public interest. And it's assessed in a completely different way. And we need that awareness. This is not Little Englanderism. It's simply a respect to a peculiar and rather distinguished history.
Mm-hmm. Now, there's a guy up there in a beige jersey. Go ahead.
I work for a charity based in the Royal Courts of Justice, which helps litigants in person go through the court process. And I would be in favour of a constitution based on Clause 40 of the Magna Carta. But after hearing the deeply insulting comments like Lord Falkshire said that only the fringes are suffering at the moment, how can you possibly trust today's government to write it?
Okay, any more points? Because we're going to take, I assume, David, you are pro for a new constitution.
Oh, definitely.
Definitely, yes. Yeah. Okay, so now anyone disagree with David? Yes, yes. This guy up here.
So looking at...
Have women all fallen silent in this audience?
Commenting on the fact that the early comment about the Magna Carta being romantic and the development of British law as a change between civil liberties, as in defining the edges of liberties, into now we're talking about the establishment of a Bill of Rights, which says what you can do. Are we at a stage now where the Magna Carta is dead and was the end of civil liberties because actually it had to define things that we were told we could do, and law has now got to American semantics where we have to list everything we're allowed to do rather than having liberties where we could just get on with our lives without government interfering unless somebody gets in the way.
Yes. Anyone else on this question of whether we should have a new constitution? I can't.
Could I?
Yes.
I've got a slightly associated question, but no one's mentioned how technology is going to change the next 25, 30 years.
That's what I was meaning.
Well,
precisely, yeah.
A great deal of what you've been saying, Rory was talking earlier on about, in 300 years' time we'll be, many more people will be enjoying our rights, etc., which is very romantic. But surely all of this, a lot of what you've been saying is romantic guff, very lovely. But what about genetically modified human beings, which are not far away? Really, even if they're only slightly genetically modified, or drones, robots, all that sort of stuff. It's all coming. Isn't that what's going to make the running for Magna Carta? Isn't that going to frame the debate in the future, technology?
Well, that's exactly what Tim Berners-Lee has begun to work on, hasn't he? He wants a Magna Carta for the internet, by which he means a Magna Carta in the modern world. And, of course, you touched on the subject of artificial intelligence, which is absolutely key in the next 50 years because we'll be run by algorithms. And I cannot imagine any robot respecting your rights.
I'd say in response to that, though, I mean, that fundamentally we're talking about humans here. And this whole debate, it doesn't matter whether we're talking about Magna Carta, constitutions, or Parliament, is about our sense of humans. Human dignity, human rights, and a world that you're envisaging, a world of genetically modified creatures, of drones, of technology, is not only a horrendous world, but it's a world that would indeed marginalize all this conversation. This conversation is based on the idea of us, of people. It's not based on some weird technological universe.
Well, but the trouble is, Brave New World in the 1930s envisaged the world you're describing brilliantly. And we are within a whisker. We are now creating, we've just created the feelies and the smellies. You all know Brave New World, don't you? Infinitely more compelling than 1984. It is an horrific vision, which we are within a whisk of, a society driven by consumerism, by travel, by leisure, by pleasure, in which you have the Archie Cant, who spends his time feeling breasts. It's not at all far from the world that we're in now. And the idea of freedom in that world is non-existent. It's a managed world. And unless we fight, unless we have that freedom of speech that so many want to take away, we'll go there.
Now, Diana, would you like to say something just before? I haven't. Would you like to say anything to this final point of whether we should have a new constitution? Can you make a passionate case for it?
I don't feel strongly about whether we should have a written constitution or not. What concerns me more is that we maintain the rule of law, and that means that we continue to have proper access to justice. And that's what troubles me more than any question of a written constitution.
I'd say what troubles me most in Britain at the moment is the idea of politics and citizenship, that we've inherited an idea which had its sort of height with figures like Gladstone, and very striking, Gordon Brown yesterday in his speech kept referring to Gladstone all the way through his speech, of man as a political animal, of our fundamental function being politics. And my experience turning up as a junior member of the House of Commons is, of course, the discovery that, according to recent opinion polls, the average person in Britain thinks about politics for exactly 7 minutes a week. So there's this huge gap between this idea that our fundamental function as human beings is to engage in the dispute and the action of politics. And I would say that Some of the formal procedural issues of rights are deeply, deeply important, but they're deeply important as a reflection of a notion of human dignity. That the more fundamental things can be re-energized also through making people citizens, through creating structures of local democracy where people can play an active role in their own communities, through moving away from this horrible world that David Starkey suggested, which is sort of teetering somewhere between King John and Benny Hill, or somewhere between sort of Aldous Huxley and Henry VIII, that horrible sort of Gothic school prison house that's the House of Commons, towards something that actually energizes people, that unlooses, and this is what I want to conclude on, the fact that we've never been so educated as a nation, we've never been so healthy as a nation, we've never been so well traveled, that the people in this room are far better off than their parents and grandparents, and yet somehow, as a nation, we're much less than the sum of our parts.
That's a tremendously interesting thought. So, before I thank the panel, I want you just to consider the question, should we have a new Magna Carta? So I'd like those, and that would incorporate a constitutional settlement, which would include the House of Lords and so forth, as well as rights. So those for a new charter, please stick up your hands. I can't see upstairs. Can anyone see upstairs? I can see a few hands, but they're only... So I would say, okay, those against. I would say it's pretty much 50-50. What do you think?
I think we narrowly won.
I think you did. So I want to thank David Starkey for a wonderful performance as ever, Diana for her great eloquence, and Rory for his great honesty, and our other guests in the audience. Thank you very much, audience, and thank you to these.